We're calling out to you, International Court of Justice, an advisory opinion on human rights and climate change. We're calling out to you.
The song you just listened to was written by star musicians of Vanuatu, calling on world leaders to adopt a resolution at the UN General Assembly and issue an advisory opinion on the obligations of states under international law to combat climate change. Vanuatu is an island nation in the Pacific, home to around 280,000 people spread over 80 separate islands. Vanuatu's economy is founded on agriculture and offshore services. 99% of households in Vanuatu rely on fishing for sustenance, and 65% of households make a living on crops like kava and copra. Climate effects in Vanuatu are urgent. In 2011, the UN gave its first ever designation of climate refugees to Vanuatuan citizens fleeing rising seas and moving inland.
Vanuatu, that is the most vulnerable country in the world. In terms of the impacts of climate change, we are seeing the impacts every day in terms of coastal erosion, but also in terms of the severity of natural disasters.
In looking out for its future, Vanuatu has begun to raise alarm bells about the effect that climate change will have on itself and other island nations.
We who have contributed the least to carbon pollution continue to bear the greatest burden. This is the context in which Vanuatu will ask the members of the United Nations General Assembly to vote with us to request the International Court of Justice to clarify the legal obligation of states to protect human rights and environment from climate change.
We have a duty to all of mankind. Legal obligations must stand to defend our rights.
The International Court of Justice, or ICJ, serves as the judicial branch of the United Nations. It settles disputes between states in accordance with international law and gives advisory opinions on international legal issues. Vanuatu is requesting an advisory opinion from the ICJ to define the rights of countries hurt by climate change.
That would purely be an advisory opinion. They couldn't order anybody to do anything, but it would be a very important statement of international law, and then would be cited by the domestic tribunals that are interested in human rights and climate change. And many of those domestic tribunals do have the power to require countries or companies to reduce their emissions or possibly to provide compensation.
The draft ICJ resolution is currently being developed by a core group of nations from all geographical regions, led by Vanuatu. The draft will be formally introduced to the UN General Assembly on the 27th of October and opened for informal negotiations in November. It will be tabled to a vote sometime between December 2022 and February 2023. The resolution highlights scientific consensus on climate change and makes reference to the specific devastating effects on small island developing states like Vanuatu.
We are hoping that the role of states with regard to climate change is clarified, and also it will help us to beef up our climate ambition.
So, knowing how important this opinion may be, what should the ICJ say? Using tort doctrine, the International Court of Justice will be able to establish a claim for negligence for international climate-related harms. Although this issue is of international scope, we can apply domestic tort principles to Vanuatu's case. A tort is a civil wrong that causes one to suffer loss or harm. To win in U.S. courts, a negligence tort claim must prove that the circumstances satisfy 4 conditions. First, the existence of a legal responsibility or duty held by the accused. The duty proposed here would be the duty to not harm other states via climate-related outcomes. Second, the accusing party must prove that the duty was breached. Vanuatu could potentially prove that other countries failed to follow their obligation to keep the effects of their actions within their borders, and breach the duty by contributing to climate-related harms. Breaches can include pollution, greenhouse gas emissions, or environmental degradation. Third, Vanuatu would have to prove causation. In the United States, courts commonly require that the alleged negligent actions satisfy 2 requirements to prove causation. 1, the but-for test, where courts evaluate whether or not the filing party's harm would have occurred without the alleged negligent actions. And 2, the proximate cause test, where courts find whether or not the cause is legally sufficient to find the defendant liable. It may be difficult to establish but-for causation in light of the multitude of factors influencing climate change. As for proximate cause, states may argue that the link between their activities and the harm allegedly caused by such activities was too remote. These issues demonstrate the importance of the advisory opinion. It can create the causal framework by which countries can get around these causation roadblocks in bringing climate cases. The fourth and final condition of a tort of negligence claim requires that the filing party prove that they experienced real harm. Despite challenges posed in proving these elements, the value of the ICJ advisory opinion is in clarifying the tort frameworks by which countries can bring climate-related cases under tort law. For example, the opinion can instruct courts on how to define multi-party causation and provide pathways for tying climate-related negligence to climate-related harms.
Now we are engaged in a great climate war.
Testing whether these island nations,
or any nation so conceived and dedicated,
can long endure.
Our homes have become a battlefield for that war.
Hearts bleed as the rising ocean
reclaims the final resting places
of those who here gave their lives that these nations might live.
We are doing what we can to stop it.
But the smoke that started this fire did not come from these islands.
These students inspired Vanuatu's movement for an advisory opinion. It is important to remind ourselves that the American legal system is based profoundly on dispositionist principles, or the idea that every actor has complete agency in its experiences and acts solely based upon individual preferences. The case of Vanuatu proves difficult for us to analyze with the same mentality. As the students point out, the Pacific Islands did not meaningfully contribute to climate change, yet it poses an outsized threat to these nations and their way of life. In the 18th, 19th, and 20th centuries, European nations inflicted permanent damage upon Vanuatu and other Pacific islands in the name of personal economic gain, destabilizing their ecosystems. In the 21st century, the global north stands to repeat history as we journey onward, unwilling to take the action necessary to avoid climate catastrophe, instead choosing to passively watch as these nations endure the devastating effects of climate change. Like a ball being kicked around, Vanuatu suffers at the hand of situational forces threatening its very existence. Vanuatu's ICJ claims must be seen in a situationist context, with due consideration of the centuries of harm it has experienced to the benefit of wealthier nations. Now, Western nations have an opportunity to atone for having set in motion devastating weather events that threaten the very existence of states like Vanuatu, and consequently the planet as a whole. An ICJ advisory opinion would serve as a much-needed signal that we are finally taking climate change seriously. Ideally, it would be the first step, albeit a small one, toward combating climate change and mitigating harm to our planet, as domestic and regional courts could then cite this ruling to further climate justice worldwide. Its doctrine, properly applied, could incentivize countries to do the right thing and create channels for retributive justice in response to wrongs. We urge the United States and all countries to join Vanuatu's coalition and support the issuance of an advisory opinion by the International Court of Justice.
United Nations, leaders of today, protect the rights of the human race, calling out to you.